I'm going to come over to you. You're Jewish. I'm African American. I actually remember one of my first cases was defending a hate crime, white guy charged with an assault of a black woman and the hate crime enhancement attached to it. But our job as criminal defense attorneys is to represent the most loathsome among us, right? They get lawyers too. They have a right to be represented. And I'm not sure about a separate hate crime statute. I think an enhancement, I'm okay with that as someone who could be subjected to this kind of act. But I don't know about a separate crime.
I don't know about a separate crime either, but it's really irrelevant, I think, for Mr. Hoque's purposes. If he's not responsible because he's operating under a mental disease or defect that rendered him incapable of appreciating the consequences of his act or to know that his act was wrong, then they can pile on whatever they want. And I think that's just what this is, piling on. I mean, you have a murder charge and a bunch of counts of attempted murder. It's almost like throwing in a speeding ticket or something. It just doesn't make sense. There's no point to it.
Well, they do that sometimes.
Yeah, they do.
Well, let me ask you this. You know, I was a public defender, so I can go on and on about how I represented this guy, but I really didn't have a whole lot of choice. The file lands on your desk, you're a public defender, you have to take it. Private lawyers, of course, have some degree of choice. Are there some cases, Frank, for you, as one of those who takes the cases that comes to you, that are harder for you to represent your client than others? Or are you able to just separate out your own personal concerns from what the legal issues are?
I can say, having done this now for close to 25 years, 10 years of that with the Legal Aid Society in Manhattan, I've represented probably the worst segments of society that you could imagine.
Frank.
Absolutely.
That's why I asked you.
And I've never turned a case down. I've never said, either in private practice or as a public defender, that you, sir, or you, madam, are too heinous a person for me to represent. I would quit my job before I did that. But things kind of change as you get older, and now that I'm the father of two small boys, I'm also caught in a dilemma because I'm representing a serial pedophile as we speak. So, you know, that creates some issues for me. But I can truly say the one person that gave me the most trouble over the years was probably 20 years ago at the Legal Aid Society when I represented a Hasidic Jew who was charged with several counts of cruelty to animals. And being an animal lover, I had a real problem with this guy. He really ruffled my feathers. The pedophile, too, but the animal torture and abuser really made me nuts.
Well, yeah, and often it's the sign of a worse problem to come. Aaron, let me come out to you. You know, for me, the most difficult cases in some way are the easiest. In Andrea Yates, for example, where insanity defense ultimately did work, there were hints of her mental illness and there was depression, but nothing as severe on record as we have in this case, and the prosecution acknowledges his long history of mental illness. So you seem to be a little more hopeful. Why? It never works. Andrea Yates is one of the rare cases in which it has.
Well, you have a hard time convincing jurors that this isn't some legal loophole, some technicality most of the time. But in this case, you have, as we discussed, the documented history of bipolar disorder with psychotic features. You have two mood stabilizers that he was on, lithium and Depakote, I believe, which had been changed at some point before this crime occurred, which I'm sure the defense experts are going to get into, the dangers of changing psychotropic medication. But as important as all of this is, if you want to look to whether or not there's proof that the guy was not sane at the time, the guy was arrested a short time before this, I believe, for standing in a mall naked or exposing himself with no history of any prior sexual deviant conduct or anything like that. So clearly, the guy was either off his right meds, on the wrong meds, not on meds at all, but he was going down that road of mental disease or defect that's going to hopefully lead this jury to conclude that he was not responsible. Not a question of well-planned, well-thought-out, calm and giving interviews, talking about a purpose. That's not what mental illness here is. That's not what that's not what this defense is about. This defense is about whether or not he could appreciate the consequences of his acts or know that his acts were wrong. And that's the issue. And having said that, I'm somewhat optimistic about this guy's defense. There was a statement by him that is somewhat troubling, and I don't know if these jurors are going to hear it, but my understanding is he made a statement, I believe, that he didn't go there to even try to kill or shoot anyone. He went there to just randomly shoot up the place or something like that.
Didn't mean to kill anyone. Didn't mean to kill anyone, or didn't go there to kill anyone.
Right, which sort of suggests, because my understanding was that every bullet that he fired hit a human being.
Right.
Which suggests perhaps that he might just have known that what he did was wrong and was trying to minimize it or mitigate it in some way by saying, hey, I wasn't trying to hit anybody. But the odds of someone going there with a semi-automatic handgun and firing off X number of shots and every one of them hitting a live body, I think might suggest that he did intend, and that his statement might suggest that he did know on some level that what he was doing was wrong.
Let me jump out to Beth Karras, Beth, because workplaces, schools, and places of worship become the scene of these kinds of mass shootings. And if you have to represent one of these folks, what's your best defense? Frank, I'm going to come to you. Frank Rothman, our criminal defense attorney here in New York, and then Aaron Kiviat, I'll get to you in just a moment. Let's talk about this insanity defense. It rarely works. If you're going to have a workplace shooting or a school shooting or any other kind of shooting, you got to think somebody's crazy on some level to do something like that. So why don't juries buy it?
Jurors don't want to buy into the insanity defense because prosecutors are usually, they're pretty effective at making this correlation between intent and premeditation and those kinds of things, and that if it's premeditated, therefore there's a rational thought process. If he planned to do this, if the person went and bought a gun and loaded the clip and went through all these steps, therefore he knew what he was doing. And it's just plain wrong, because it can be premeditated from its inception until the completion. You can plan it in a million steps, but if you're operating under a delusion, under some false mental belief that what you're doing is mandated by a voice you're hearing or is the product of plain old mental illness, then you're not responsible. But Mr. Hoque has a great tool in his defense, and that is he's got a documented history of mental illness.
Yeah, he's
been on meds for 10 years.
A very long and undisputed history. The prosecution agrees that he has a history of mental illness. But then let me jump over at Frank Rothman. I know you are no different. And so I want to ask you some general questions about the Fourth Amendment, Frank. And, you know, Susan, she was giving me a little bit of a hard time there, suggesting that the state is well within the bounds of its authority. And it is if a crime has been committed. But there are still rules about probable cause and confidential informants and the validity of what you offer to the judge to get that warrant to go onto that property and remove these children. What if it turns out there is no Sarah, the alleged 15-year-old girl who called to report the abuse that triggered the raid? What if she doesn't exist? What if she really is Rosita Swinton, a 33-year-old woman who has nothing to do with the FLDS? What does that do to this case, especially when we look ahead to a criminal prosecution?
Well, that's what you heard the lawyer for the FLDS suggest. He used the language that some evidence could be tainted, and that's a word that lawyers use in criminal cases. And it sounds like he's lining up his fight to try to prevent the DNA that's being taken from being used in a subsequent case involving endangering the welfare of minors or sex with minors. Sounds like he's gearing up for that. But you're right, there's been no proven criminal conduct. There's been no magistrate or judge who's made a decision at this point that there's something criminal or something so looking like criminal that it warrants the broad strokes that the state is painting right here. And to flat out remove, I mean, it's unheard of to remove mothers that are breastfeeding, and a judge making a remark that, well, in this country, breastfeeding comes to a halt when parents decide to go back to work, as if that has some relevance to what's going on here. Sounds bizarre. And I assumed when I heard you or somebody make that statement that the judge was a male, and then that just jolted me.
No, she's a woman. We don't know that she's a mother, but she is a woman. She's very well respected, well regarded, tough nose, apparently has a very good sense of humor. But there's nothing funny about this situation, because what we have, I think, Frank, is, and look, it's it's an unpopular position to defend the FLDS because basically it's an oddball group in our country. But I've been defending them, Frank, because I don't like the idea of the state storming in and removing 400+ children.
I don't either, Jamie. But when you run into the situation where you have children who, it seems, and I know that's not a legal standard, but it seems like they're in danger, that this is some emergent situation.
It seems like they're in danger, Frank, because they look funny, and because there are rumors and there's a history in their faith of young girls marrying older men. Well, guess what? There's a history in most religious doctrine of young girls marrying older men for the purpose of procreation. I feel, Frank, that if the state thinks something went on there that was illegal, they need to prove it.
I agree with you 100%, but what do you do during this potentially emergent situation where children are living in that environment? It's a fine line. It's going to be really interesting to see what the judge in Texas ends up doing, but I don't think you can wait all that long until something is to what standard?
They've waited 187 years. These people have been around. All right, look, Frank, I'm going to let you have the last word there because I get a real last word at the end of the show, and I'm coming back to this subject, surprise, surprise, at the end of the show. But I thank you for that, and I now want to have a big old conversation with you about this separately, Frank, so I may hunt you down there in MP1, and we can continue our conversation. You're going to stick with us because we are going back out, and that the firearm issue is perhaps less significant. But, Frank, I still want to ask you about it because here in New York, of course, very different for us practicing in the tri-state area than, say, in Texas or some of our southern states in this country. And it adds one more hurdle, I think. It's interesting to hear what Aaron says, that if you were anywhere else in the state of Washington, you might have a jury that looked more like a Texas jury. It would be one less thing for you to have to overcome. But in Seattle, it's an issue for someone to have a firearm, let alone use it in this horrific way.
I agree with you, Jamie. I don't think the gun question is an issue for this jury. This is a case that I believe can be won by the defense, and this is going to come down to a question of how good this guy's experts are in dealing with the issue of the psychiatric defense, the insanity, the not responsible defense. This isn't about guns. This isn't a referendum on whether or not people should have access to guns or not, or whether or not Mr. Hoque, who's looking quite crazy as we see him there, should have been able to go into a store and wait a couple of weeks and then get a gun, even though he had a pending misdemeanor charge of exposing himself at the time. I mean, all that is interesting, and it's kind of an asterisk, but the main question is, for this jury, is going to be the psych issue and whether or not this guy should be held criminally responsible for what he did. And like I said, I agree with you. I think this is one that has a decent shot of being won by the defense. And that's just not from a true believer. That's from a reasonable man standard.
The reasonable person standard. Okay, well, we'll bring my guests back into the conversation, Aaron Kiviat and Frank Rothman. And I want to ask you both, as criminal defense attorneys, how you deal with this kind of testimony. Obviously, our focus in this case is on Mr. Hoque's mental state, but we can't ignore what the jury has heard and the very human reaction jurors must be having to this emotional testimony. Frank, first to you.
You got to deal with this during jury selection. You have to desensitize the jury from day one that this is going to involve very emotional testimony, that at times you as jurors might feel a tremendous amount of sympathy for the victims. You're going to be horrified and mortified. You have to let them know what's coming. Once they kind of have a heads up that this is going to tug at their hearts for the next couple of weeks, then this testimony, although clearly damaging, is, I don't want to say negated, but it's softened to the extent possible. They have to know that this is coming, or else it's going to have much more of an effect than we as defense attorneys want it to have.
And we always say you begin trying your case in jury selection, but perhaps more so in some cases than others, and this would be one of those. Sure.